consider today, I mean, the motion, it's a motion, that has brought about this public hearing was motivated by my experience before coming to the House. I was a staff of Lagos State government, and specifically the permanent secretary in the Ministry of Commerce and Industry for 6 years. So I interacted a lot with stakeholders in the commerce and industry sector of our economy. And by virtue of that position, I realized a lot of atrocities being perpetrated in the Nigerian economy, which we feel that it must be addressed, and then we put an end to it. The fact cannot be gainsaid that casualization as a recruitment strategy has over the years assumed a worrisome dimension within the Nigerian labor market, with employers of laborers in both the private and public sectors adopting on a large scale this method of recruitment to the detriment of the nation's teeming working population. Beyond the ignobility of this method of engagement on the seemingly vulnerable Nigerian workers is the exploitative tendency it confers on the employer of labor, who in a bid to maximize profit at all costs, choose to capitalize on the rather high level of unemployment and the accompanying poverty in the country to engage workers under working conditions that are largely undignifying and inhuman. Workers in this category do not have permanent job status. They do not get same pay and benefit with their colleagues in permanent employment for doing the same job and working the same hours. Casualization, to a large extent, represents a form of involuntary servitude to which workers are subjected over a period of time. Desperate job seekers within the labor force are exploited into taking up job offers for survival purposes as against dignity. Whereas, going by the provisions of Section 7.1, Part 2, Cap 198 of the Labour Act, no worker is supposed to be engaged on probation or temporary employment beyond the period of 3 months. It is, however, disconcerting that employers of labor in the country now find it convenient to circumvent the provisions of the law through the adoption of unethical business practices such as casualization. It is now commonplace for employers of labor to outsource jobs to firms to recruit workers on their behalf on questionable contract terms as contract or casual workers as a cover-up for their illegality. From my personal experience, particularly in some banks, there are workers, I know of 1 or 2 workers that have worked in a particular bank for more than 10 years and yet not confirmed, not promoted over this period of 10 years. And eventually, one of them was laid off. While this unwholesome practice cuts across organizations, both in the private and public sector of our economy, its prevalence is clearly evident in the banking, oil and gas, construction, mining, and telecommunication sectors, which coincidentally are high-profit earning organizations. According to reports, it is estimated that the number of casual workers in Nigeria is about 45% of the entire working population, implying that out of every 100 workers, 45 of them are casuals. With the present economic recession, this estimate is likely to increase on account of the drive of employers of labor to reduce cost of production. Distinguished ladies and gentlemen, it is pertinent to stress that having ratified the ILO Convention as one of its member countries, member countries is under the obligation to respect, promote, and realize in good faith, the principles concerning fundamental rights at work. Regrettably, however, we have been indicted as a country to be in contravention of this convention on account of frequent termination of contract workers' employment at a time when they become qualified for transition to permanent employment. While one expects the organized labor through its affiliate bodies such as the Nigerian Labour Congress and the Trade Union Congress to intensify the clamor for the eradication of this scourge in the interest of the Nigerian working population, there appears to be a lull in their advocacy in this regard, leaving Nigerian workers seriously deprived of employment benefits with no legal status and easily dispensable at the convenience of employers of labor. Worrisome is the fact that foreigners are now seen doing most routine jobs in Asia-owned businesses in clear violation of the expatriate quota regulation that restrict expatriates to specialized and highly skilled jobs that Nigerians cannot effectively execute. The implication of this unethical business practice is manifested in increased unemployment, slave labor, prostitution, psychological trauma, violation of the rights of workers, and reduced productivity. Ladies and gentlemen, the time to act is now. While the provision of Section 17E of the Constitution guarantees equal pay for equal work without discrimination on account of sex or any other ground whatsoever, the discrimination in pay persists. We must concert efforts to generate the much needed political will to reduce compliance, to enforce compliance to decent and dignifying working conditions in Nigeria. On our part, as lawmakers, it has become imperative for us to take a critical look at the Labour Act with a view to making necessary amendments where necessary, so as to stamp out this scourge while ensuring that the interest of Nigerian workers is protected and its rights guaranteed as stipulated in our Constitution.
It gives me great pleasure to welcome you all to this important investigative hearing on the urgent need to address the problem of casualization and outsourcing of jobs and its socio-economic consequences. It will be recalled that the House of Representatives, as its sitting on Tuesday, 27th of September 2016, mandated this committee via House Resolution number 83, HR 83, 2016, to investigate the incidence of casualization and outsourcing of jobs in both the private and the public sector of the economy, and report back to the House for further legislative actions. Casualization is a practice where a worker works in a full-time or permanent position without the regularization of his employment, while outsourcing is a practice used by public and private establishments to subcontract or transfer portions of their work to outsiders in order to focus on the core responsibilities. Casual workers in Nigeria perform the same task as permanent workers, but without any job security. They are frequently laid off, particularly just before they will become entitled to permanent contracts. They are also exposed to worsening health and safety situations, with increased cases of death and injuries at work. A significant number of people in Nigeria opt for casual jobs, not because they lack skills and qualifications, but because of the low employment rate in the country. It has become the order of the day, as it is now so rampant in all sectors of our economy, ranging from banking, insurance, telecommunications, oil and gas, etc. In Nigeria, companies are replacing their full-time workforce with temporary, casual, outsourced workers at a frightening rate. They engage in this practice in order to cut costs and maximize profit, while denying workers their rights, such as the right to membership of trade unions, in contravention of Section 9 of the Labour Act. The practice of casualization contravenes Section 7 of the Labour Act, which mandates that an employer should provide the employee with a written contract of employment specifying the particulars of employment not later than 3 months after the beginning of the employee's period of employment with the employer. Section 23 of the same Labour Act also specifically requires a recruiting agent to obtain a formal letter from the company commissioning him or her to recruit for them, and also a written permit or license by a serving Minister of Labour. Nigeria is also a signatory to the ILO Decent Work Agenda, which calls for opportunity for work that is productive and delivers a fair income, security in the workplace, and social protection for the families, better prospects for personal development and social integration, freedom for people to express their concerns, and equality of opportunities and treatment for all workers and men. For emphasis, the effects of casualization and outsourcing are detrimental to our socio-economic development as they result in low incomes, job insecurity, non-payment of salaries and pensions, long hours of work without overtime payment, denial of sick leave and payment for sick leave, denial of annual leave and maternity leave, poor health and safety conditions, non-payment of compensation for injuries sustained at work, poor working conditions, poor motivation, and lack of social protection. In light of the above, this investigative hearing will want to ascertain the extent of casualization and outsourcing of jobs by both public and private sectors of the economy and prefer solutions to end this continued exploitation of the Nigerian worker. I want to assure you all that this investigative hearing is not intended to victimize or witch hunt anyone, but is rather a fact-finding exercise which will help the House of Representatives in taking decisions that will bring enduring sanity to labor practices in the workplace. Let me therefore conclude this address by welcoming you all once again to this public hearing as we look forward to a successful deliberation. Thank you for your attendance and attention. God bless us all.
It's always there once it concerns workers. So I think it deserves an approach. Also, when terms the act of outsourcing jobs meant for qualified Nigerians and the casualization of Nigerian employees by both public and private sector employers, this hearing is convened pursuant to the resolution of the House in that we have on Tuesday, 27 September 2016. I have continued to hold the view that unemployment is one of the greatest bans of our nation. Accordingly, any act of outsourcing jobs meant for qualified Nigerians or the casualization of qualified Nigerians
address this issue of casualization. We will invoke the relevant sections of our Constitution to compel them to come before Parliament. That I will assure you, that they will appear before this committee. Any organization that is not here, I will give you another opportunity to appear before this committee, after which, like I have said, the relevant sections of the Constitution will be invoked to compel you to appear. So let us start with organizations who have been invited.
The permanent and pensionable staff of the agency. In line with our mandate, the summary of your distinguished honorable members are respectfully invited to note the following about NIMASA. That the Nigerian Maritime Administration and Safety Agency, NIMASA, is the maritime regulatory agency of Nigeria, as is the apex regulator. That the agency, by virtue of its global outlook, aspiration and expectation of the industry, is always guided by national and international laws and best practices in all its operational and administrative functions. That the agency is empowered by 3 legal instruments to carry out its core mandate and operational mandates: the NIMASA Act 2007, the Merchant Shipping Act 2007, and the Cabotage and Inland Act 2003. Administratively, the agency employs the provisions of the Condition of Service, COS, that is the agency's Condition of Service, and the Public Service Rule, PSR, and other extant policies in terms of circulars, current circulars from the head of service and subsequent other organizations. That NIMASA, in line with extant rules of the Federal Republic of Nigeria, does not engage any casual workers and have none in its payroll. Thank you very much, honorable members. And our courier services, as well as our security services. These are the 3 things we outsource in NIMASA.
Okay, have you given the names of your outsourcing?
Yes, it's included in the brief.
And you also filled in the form you were given?
We received the form this morning.
Had engaged the services of casual laborers, contract staff, laborers, contract staff. But since 2007, Central Bank has ceased to have such kind of staff again. Like the chairman said, we have outsourced some of our functions
very much. The issue of casualization by transferring it to another person to do it on your behalf.
In our case, it's not out of our way, pays out certain categories of workers completely from the system. And because of that, we have to go through the other way to engage services. There is no way we can operate to that clearness.
Okay, we'll come to that.
Has the sole responsibility of transmitting what we used to have honestly. But from 2012, after the severance, due to the privatization of the company, PSCN, we put a full stop to it. That is in agreement with the labor union. We regularize the casual staff that are qualified, and then we put a full stop to casualization. On outsourcing, Honorable Chairman, we don't have any outsourcing except for cleaning job in the headquarters, corporate headquarters only. And that is for obvious reasons really. We tried, to be honest, to outsource some, especially in the outstations, but so far we have not done so, and that has been withdrawn. However, in spite of, there is no need to outline the advantages of outsourcing to the committee because we have already set it aside. So, Honorable Chairman, this is so number one, we don't have casualization. Number two, we have only one outsourcing.